You uh, you tell us a date.
On 30th of this month?
30. Okay. List on 30, 1/2024 as prayed for by Learned Counsel for the Learned Instructing Counsel for the appellant. As Jahan Learned APP is present.
I beg to mention division appeal for visiting lordship, and as IA is pending for bail is also pending. IA is there for bail is also pending.
Court master, he'll have to make some adjustments.
Next week.
I'm not saying next week. Let him make an adjustment. Yes.
With regard to item number 5, my love.
Yes.
Today I'm a handicap because my assisting counsel has gone for his medical treatment to Hyderabad, my love.
Oh.
I pray for adjournment. I've informed the other side, my love. So convenient date, if your lordship kindly permit it, is on 38, my love.
30.
30. I'm sorry, my love.
No, it's okay. No, it's okay.
Assisting counsel is not there, my love.
No, it's okay. What's as usually just say on the prayer made by Mr. Z. Kamar, Senior Counsel, the matter stands adjourned today. Mr. Digedas, Learned Standing Counsel for NIA, as well as Mr. S. Jahan and APP for the state are present. List on 30
30.
January 20. Yes, Mr. Das. Seen you after a long time.
Item 1.
I see you had some difficulty in walking. Any problem with that?
The joint time is a little bit trouble for last 20 days.
Okay. Okay.
Remember, in this case, let me do it.
Hmm?
Yes,
Yes, yes. Just a moment. Give us 2 minutes.
well, in this case,
No, just give us 2 minutes.
Applicable also, no? But in this case, one Rajan Nayak, my lord, has been convicted under section 302 IPC by the learned additional session judge of Vishwanath Sariyali, and he has been sentenced to life imprisonment with fine of rupees 2,000 in default another 1 month's imprisonment, my lord. But in this case, the prosecution examined altogether 7 witnesses, my lord. Out of those 7 witnesses, my lord, only 2 witnesses, PW1 and PW4, claim to be eyewitnesses, my lord. Others are reporting witnesses, my lord. They have heard the thing from other persons. Now, other PW1 is the mother of the victim, Naku Nayak, and she is also the informant of the case. The learned additional session judge, in its judgment, and is my lord, in its judgment, my lord, in para 11, last line, has held, and that rightly has been held, my lord. Thus, upon scrutinizing the evidence of PW1, we find that her testimony against the accused is irreconcilable, and therefore she is not a reliable witness, my lord. So her entire evidence has been discarded by the learned trial court, my lord. Now remains the evidence of PW4 only, my lord, who claims to be an eyewitness, my lord. My lord, PW4 is also not reliable, my lord, in my humble opinion. May I read the evidence of PW4, my lord?
Mr. Das, I think it was incorrect on part of the trial court to discard PW1. You see, the date of the offense is 24/4/2013. This evidence was recorded of PW1 on 14 October 2015. So, having seen the son killed in her presence, she says that from last 2 years, I can't see with my eyes. So 2 years is not the date of occurrence. Before the date of occurrence, after the date of occurrence, he can't see.
Another thing, my lord,
She said that during that time my eyes were okay. But there's one more thing. She said that the incident happened in front of her house. But the sketch map, of course, doesn't show her place. But one other witness said that it's not possible to see. I mean, the place of occurrence is although in the front, but there were other houses. It is not possible to see from the house of the victim.
For that reason, it was discarded.
That was also a point and eyesight.
my lord, PW2 in the current
No,
draft
no, you
line,
see, no, you see, that can't be accepted.
Ah.
Number one, this witness PW1, when she was cross-examined, had evidence that she did not see the occurrence, could not be brought home. In cross-examination, she says, it is not a fact that occurrence did not place in the paddy field. It is not a fact that I did not see the occurrence myself.
She stood on her own, yes, but then that factor, because it's a life sentence and eyewitness has to be scrutinized. Now here, what I find is little difficult for prosecution, not even see the other evidence.
So it's okay, but we are now examining
Ah.
vis-a-vis paragraph 11. It was discarded.
Paragraph 11 of the judgment.
That is what Mr. Das has referred to.
Mm.
But once we independently examine this evidence, then we find that so far as cross-examination is concerned,
Ah.
that she was not an eyewitness, could not be brought home.
Demolished, yes.
what my friend has stated, Miller, the PW2, the last line of the gross example.
No, it's just, Mr. Das, I'm just thinking aloud. I'm not, we are just discussing and thinking aloud. In front of me, Ms. Jahan is standing. Correct. There's another learned lawyer behind her. I can see her also. But I'm saying that Ms. Jahan is in my front. Does not mean that in the back I can't see. House is in front, that is okay. If somebody asks me whose house is that, I'll say in my front is the house of so and so. But but the question would have been, the house in front of you would have clouded your view, would have obstructed your view. Then what is the answer? We will have to examine that. In my presence, in my front, she's there. And you're also there, but she's also there. And behind her, since there's a lawyer sitting, I'm just referring to her, not you.
That is a possibility. Even if the houses are there, she could still see. But then there are other witnesses who say
No, it's okay.
not
No,
possible.
no. We are only on one right then.
Ah.
Others we have not read.
Okay.
So we are not, we are on one only.
Another thing, Miller,
Hmm.
the distance of the place, the distance from the place of occurrence in the house of the PW1 where she was, from where she claims to have seen the occurrence, Miller, is half a kilometer. It is on the evidence. And
Okay,
it
no,
is-
no, we have not seen the other evidence, but we'll come to it. Since you referred to paragraph 11, we have started to, what you call, examine this evidence. Yes, so that is one.
I'm coming to PW4, Miller.
Charge sheet was submitted on which date? Uh,
Sheet on 25 or 30th of 2013. After 2 months.
30,
2013.
because we find that this accused himself surrendered before the police station.
No, the police says he had arrested. Mother said,
Surrendered.
but
Because there's no evidence of somebody catching him.
no, but then police said they went to the place and they found him and then apprehended.
Yes. Yes, Mr. Das.
I want to draw your doctor's attention to evidence of PW4, Miller.
PW4. Okay.
He claims to be an eyewitness, Miller. and he claims that he had seen the occurrence himself. So here he shows, I know both the parties about 2.5 years ago at about 5 p.m. The accused person altercated with Natunayok deceased, and then the accused person assaulted Natunayok on his backside with a dowel, and as a result, Natunayok fell down on the ground and died on the spot, my lord. In the same, myself and other 7 people went there, and I informed the police about the occurrence. After some time, police came and took the dead body to BLEPL for post-mortem examination. So in the cross-examination, he has stated, mother, the occurrence took place on the western side of my nursery. He has got a nursery, mother. Around LP school is situated to the western side of my nursery. At the time of occurrence, 6 7 persons were working in my nursery. I do not remember the date of occurrence. Please recorded my statement. It is not a fact, my lord. This is important, my lord. It is not a fact that I did not state before police that the accused hit the deceased on his backside with a dowel. This is an important contradiction, my lord. I did not state before IO that accused said us with dowel when we tried to catch him. I do not know when the complainant lodged the affair. I only saw the injury on the backside of the deceased near the neck. It is not a fact that I have deposed falsely, my lord. My lord, in this respect, I want to point out only 2 things, my lord. He has claimed that he had seen the accused assaulting the deceased with a dowel from the backside. And as a result of that assault, the deceased fell down and died on the spot, my lord. Now, my lord, I want to draw your lordship's attention to the evidence of the doctor, my lord. PW6 at page 14 of the paper, my lord. Now, here the doctor says upon cut injury over the occipital region of the scalp side, so, full skin of the scalp. Then he found multiple cut injuries over the front and right side of the neck, involving the thyroid, cartilage, and larynx, my lord. Now, my lord, this finding of the doctor, my lord, shows that all the injuries were caused from front side. There were multiple injuries, not only 1 or 2, multiple injuries. Larynx, thyroid, all were damaged. That means he was assaulted from front side, my lord, not from back side. That is one very important question, my lord. And if he had assaulted from the front and back side only, and he saw that the accused assaulted the deceased with a dowel only from back side, and as a result of the assault, he fell down and died there, then and there. But the doctor's report shows that the injuries were on the front side, not on the back side of the neck.
We're just thinking aloud. You see, the description of how the assault took place is not there. it is very concise that he hit from the back. Now, hitting from the back, let us say that he is hitting like this, injury in the back. If he is hitting like this, there is a possibility that the thyroid and the cartilage, thyroid cartilage and the neck would snap. Because if the assault comes this way, because the dowel is a bit curved. So there's a possibility because there's an injury in the occipital region.
That below down of this portion, Mother, this thyroid will be here.
This, what you call this, extension of ligature is not to the back. Let us see the injury report because,
Occipital is at the back of the,
no,
occipital area is at the back.
no, what I'm saying is that, you see, there's a cut injury. That cut injury will have a deep side cut and then it will, what you call, it will be, the depth will be lower at the end. So therefore, if it is hit from behind, the cut will be more here and then it will diminish while in going back. So what is that description here?
Right, the lordship is correct, right side of the neck involving, so. Right side of the neck involving thyroid cartilage and larynx.
That, what do you call this? Flow of the cut is not available.
The lordship is correct while giving the hit. It will fall here and then right side.
No, right side is okay, but right side, this depth will diminish. You understand that?
Yes,
The injury will be sharp on the place where it is first hit.
yes.
And then it will, the what you call, the cut injury will diminish. That means that will reflect the place from where the dowel is being pulled up.
But that is not very clear where it was hit first. Where the main hit landed.
The injury would be from left to right, right to left.
But
That
this is
is,
not such a discrepancy that lordship.
no, not that, not that. But we are trying to understand. Once Mr. Das is saying that, you see, when he's making a submission, we'll have to appreciate his submission. So whether that submission is acceptable or not, that is the decision we'll have to take. Where he says that if it is from the back, then how neck is cut? That is the question he is posing.
Yes.
Once a question comes, we'll have to answer it.
Mother, the
Neck is
thyroid
cut,
will
so
be
from the
about
front.
2 inch below from here, Mother, from the back one, it will be nearly 2 inch below that. If it's like this, from back side, Mother,
It will not come, reach here.
possible to come to this side.
He has to be at the side at best.
I have another.
Because he has a lot of experience. We'll have to, you have to respect his, what you call, experience.
Yes.
I have got another.
How many years?
In his evidence, my lord.
How many years? 30 years.
Yes, ma'am.
30 years experience there, yeah.
Human hold.
Here, my lord.
Experience in this side.
I started practice from 2014, madam.
Oh, not very long.
No, experience in this side. How much?
I don't.
No, अपना
Huh?
अपनी area
Service, sir.
Mhm.
I was about 35 years for legal service.
So 35 years experience.
So, we have to respect him for that.
Deserves.
Hello. I want to draw another, that this PW4. They had stated that it is not a fact that I cannot state before police that the accused hit deceased on the back side with a dowel. He claimed that he had stated this fact before the Ayu Mandal. But what the Ayu says, Mandal, Ayu says, no, he has not stated me before Mandal. Now, I would like to draw your lordship attention to line 5 of the evidence of PW7 Ayu, that page 17 of paper book, my lord. Here they say witness Bhaben Mali, this PW4 medal. did not tell me that the accused had assaulted the deceased on his back.
On his back.
He had stated before IO that he had seen the accused assaulting the deceased with a dog. In court, he deposed that he had seen the accused assaulting the deceased from backside, but this fact was not stated before the IO ballot. You have confirmed it. Page 5 only.
नहीं आता है ये तो नहीं हमें क्लियर कर Yes.
Madam, next thing I want to draw your attention. Your Lordship may go to page 36 of Kaparbuk, my lord, the seizure list. Now the IO is a IO is a very enthusiastic and award jealous in this case. It is from his evidence, my lord. Madam, the
Page?
seizure list, page 36 of Kaparbuk. It says, I, SI Rajiv Rohai of Bordown, OP, yes, Bihali, you hereby seize the below mentioned weapon, that means the dog, from the possession of the accused, my lord. This is very important. Possession of the accused, Sri Rajan Nayak, in connection with the above mentioned Jeep, general diary entry reference in presence of the below signed witnesses, my lord. Now, my lord, I want to draw your lordship attention to the evidence of Video Plus 7, the IO, at page 17, my lord. Page 17, the second para, line number 1, 2, 3, 4, 5, 6, 7, 8, my lord. Here, in cross-examination, he says that on the day of the occurrence itself, I found the dog lying near the dead body at the place of occurrence. None of the witnesses had shown me the seized dog. So, my lord, in the seizure list, to make the case very tight, he says that he had seized the assault weapon from the possession of the accused, my lord, to make the case very tight. But he forgot this, my lord. And what he remembered in the after visiting the place of occurrence, he had seen that the dog was lying near the dead body of the deceased, And nobody had seen, and he had seen it from the field, my lord. So how these two things can be reconciled, my lord? So this entire case, my lord, is shrouded with doubt, my lord. But I should be very sincere and clear and truthful in deposing in court and in making investigation, my lord. So the law was not from the position of the accused, my lord. But he incidentally stated that I have seen the professional, very much evidence he made the opposite statement. So, my lord, PW1 cannot be like because it is not possible on our part to see the occurrence from our house. Because the place of occurrence is about half a kilometer away from our house and it is intervened by several houses, my lord. And PW2 has specifically stated that it is not possible to, it is not visible, the place of occurrence is not visible from the place or from the house of the informant, my lord. PW2 has specifically stated that. So PW1 is also not a witness and PW4, his evidence is also very shaky, my lord. He cannot be relied upon which one is true, cannot be certain. Therefore, no evidence remains, my lord, to convict the accused person here.
Yes.
As far as the present case, there are only two eyewitnesses. One is the PW 1 and 4. Now PW 1, the eye visibility we may discard because 2 years back the incident took place, and she at that time her eyes were okay. But the fact remains, PW 2 said it's not visible because there were so many houses. Lordship will see the last line of PW 2 statement at page 10. There are many houses between the place of the last two lines. Now, his statements are also, I don't know, it's fishy because he said the deceased was his brother, but then he again addresses the mother of the deceased as aunt. As aunt. Lordship will see, he said, when I was pulling rickshaw 2 years ago, incident took place. One villager informed me that Rajan Nayak cut my brother, Noku Nayak, with her dowry. Then and there, I returned back home and took the dead body of my brother to Behali police station, health center, along with the police. Thereafter, in cross, Lordship will see, Doku Nayak is my younger brother. I do not know the name of the person who informed me about the occurrence. I do not know in which part of the body my brother sustained injury. When I returned back to my home, my auntie, the complainant, told me that the accused person assaulted Naku Nayak from the backside with a dowry. He doesn't address her as mother. There are many houses between the place of occurrence and the house of the complainant. As such, place of occurrence is not visible from the house of the complainant. Without any ifs and buts, he is so clear in saying that it's not visible. So we'll have to take whatever is there.
This can only be taken as a mistake of the court in writing as aunt. The
Perhaps,
reason is very simple. We come to page 8,
yes, 8. Got you.
PW1,
Huh.
Sukurbani Nayak, late father's name, late Prahalad Nayak.
Prahlad Nayak. Yes, here also Prahlad Nayak.
So he can't be father. It has to be husband. So it's a mistake of the court, number one. Number two, there is one other aspect.
Ah,
Uh, this is because of special relationship I share. You see, in the front door of my house is a family where the son calls mother Bhavi, because what happened was that it was joint family and all people
acha.
used to address her as Bhavi, and therefore this son also
from the childhood.
from the childhood calls mother Bhavi.
It happens. It happens. In fact, my mother used to call my elder sister as Bulbul, and when my niece, the day she was born, she always used to hear Bulbul. So for since long, she had been calling her Bulbul. So it happens. It happens. So what we say is, here he is very clear in saying there are houses and it's not possible. So even if we discard PW1, PW4 is there. He had pointed out the contradictions, but contradictions, what I think is only in respect of the backside. What police said, he is very categorical in saying that I had seen. I had seen Noku Nayak falling down, he had seen accused person hitting him on the backside with a dowry. And backside, as your lordship said, that occipital region is at the backside. Another witness also said that he was hit on the backside. So from a distance, when a person sees.
But something must be wrong, you see. Number PW2 took the dead body to the PSC along with the postmortem, police with the postmortem. Very difficult for him not to see the injury, cut injury. Very, very difficult to accept. That is number one. PW7, who is the IO, he says that he did not find any blood-stained cloth or articles at the site. But it can't be if a thyroid gland has been cut and then this carotid what you call carotid artery has been cut. There has to be profuse bleeding.
These are strange things, of course. They had seen, he said that what part he has received injuries with, I do not know. Perhaps it was all blood everywhere, so he did not know what part was hit. PW2 statement, I'm saying.
No,
Of course, not
you see,
finding.
these things will matter because you see it's a fresh injury.
Ah.
If we believe the IO, the dead body from the near the dead body, he collected this dao.
This
But
is,
it was not sent for forensic. Whether it had blood or not, we don't know.
these things they do, hardly they do. It would have been the clinching evidence then. So PW4, Lordship will go to PW1 even if we discard her statement. PW4 is consistent in saying I have seen. And the contradictory part is only in respect of backside. I may see the 161 statement of Bhavan Mali, PW4, if at all he had said, because there seems to be some contradiction. But I can just check that up. LCR goes. If LCR.
We may not appreciate
Lordship.
appreciate this at this moment, but we will
Only to
have a
see what
satisfaction.
kind of a contradiction is brought forth. Because the line which my learned friend had shown, it's witness Bhavan Mali did not tell me that accused has assaulted the deceased on his back. So perhaps assaulted part is there. Backside it was not stated to the police. So if that interpretation is taken, then PW4 there is nothing to disbelieve.
Here I want to say one thing, Lord. Now, suppose I am examined by the IO, my lord, but whether you have seen it or not. If I had seen the occurrence, I would have certainly said that I saw the occurrence and I saw the accused assaulting the deceased from backside. I won't say that he assaulted the accused. From backside, certainly he would have mentioned, my lord.
Now let us see. This Bhavan Mali's, of course, this cannot be, but for justice, Lordship can always consider. I'm a businessman. It is true that Rajan Naik had killed Noku Naik today evening. It's in English. At about 5 p.m. with her dhow. At first they quarrel. Oh, so it is true that Rajan Naik has killed Noku Naik today evening at about 5 p.m. At first they quarrel with each other. And later Sri Rajan Naik killed Noku Naik. The whole incident happened in front of me. I thought that Sri Rajan Naik will flee away from here. So I immediately informed the matter to Borgaon outpost over telephone. So as far as assaulting part, he had said to the police, there is no contradiction.
My lord, I want to say one thing here. Section 162 of services says, my lord, that no statement made before police officer shall be used during trial for any purpose.
Except
That
for
is the-
contradiction.
And should the Honorable Supreme Court also held in AR 2014, Supreme Court 2943, that statement before IO, statement before IO is not at all admissible. Should be discarded. It should not be like that. So this is a statement recorded by IO, and I have already stated before your lordship that IO is a variant situation. He did not seize the dhow he seized the dhow from the field, but in the seizure list, he stated that I seized it from the possession of the deceased, just to convince the people, convince the court in due course that he is involved in the case. The entire case is not solved in the same.
There are so many flaws. I can see even in the sketch map, the house of victim was not shown. At least we can have a glance whether she could have at all seen. But it was not referred. The house of the victim was nowhere shown. Other witnesses are not of any use. They are all hearsay witness. Only PW 1, 2, and 4 will be important. I tried to get a decision, I couldn't find any. That for greater justice, a statement before the police officer can be seen in case something comes up in the contradictions. But I couldn't get any. Because it happens many a times. The witnesses says something to police, but in contradiction, it was something was brought, which is exactly not the contradiction, but in respect of something else. Here is also a case like that, because backside he did not say, but the main part is not contradicted. Because here, reading PW2 statement, PW1 statement goes in a way. So PW4 stands. One single eyewitness is enough. And seeing from half a kilometer by the mother is also not very normal, not believable.
One
Even when it comes to PW4, in his examination in chief, it's not mentioned where he was standing.
He was in the nursery.
He was in the nursery, then he had got another 6-7 persons with him, my lord.
Those are
Those
not,
persons have not been
not
examined. There.
examined.
Any one of those 7 other non-eyewitnesses they were examined, but those 6-7 persons who claim to be have been were in PW4, my lord, they have not been examined. If PW4 was with 6-7 other persons in nursery, they also have seen the occurrence, but they have not been examined.
No, where was he?
Where was he? It seems because he said,
He has not stated that he was in nursery.
no, in his cross-examination, Lordship will see, took place western side of my nursery. Chilarai LP school is situated to the western side. At the time of occurrence, 6-7 persons were working in my nursery.
Where he was, that is not mentioned.
Yes.
No, you see, even even if you come to page 44, 45, nursery is not there, so you can't
Uh-huh.
visualize.
Nursery is nowhere shown.
This station was not once to be. From where he has seen the incident.
One statement, seeing the same, myself and other 7-8 persons went there. Myself and other 7-8 persons went there. And I informed police. So 7-8 person, in his cross-examination, he said 7-8 persons are working in my nursery. So perhaps these 7-8 persons, same 6-7 persons, he said, they were working in my nursery. 7-8 persons, maybe someone else also, we cannot deduce.
Where was the nursery?
But it's not shown. Those flaws are of course there.
Where is the house of the complainant?
Not shown. This is what I'm saying. It is not shown. Because Sintamani Nayak. It is Sukumani Nayak. Or Nantu Nayak, ki Nayak? Naku Nayak. No way, it's not shown. Paddy Field, Outpost, Devan Nayak. Chintamani Nayak, he died. LP School, Tea Garden, Sujjabora, Behali, and it was very perfunctorily made sketch map. Chintamani died, it is reflected in the charge sheet.
His nursery. There was no mention.
Not sure.
My lord, I want to discuss one more thing, my lord. In the IA, under section 389 service, my lord, this accused was allowed to go on bail, in suspension of the order of conviction and sentence. But he has not yet been released from jail, my lord, because there is no bailer.
He's inside.
I am disclosing it before Lordship, my lord, but that order was there.
He would become entitled to be released on personal bond,
Personal bond.
25/3/22.
In fact, Chintamani Nayak, who died during the trial, he was also an eyewitness.
Is it?
But his statement only under 161 is there, he could not be examined.
What he stated in 161?
Chintamani Nayak said that today at the evening, because his house is contiguous near the place. Today in the evening time, I was at home. I heard some noise in the backside of a paddy field of our house. When I went to see what happened, I had seen that both Rajan and Naku were quarreling with each other. Both of them were in a drunken condition. After some time, Rajan Nayak had taken one dao and injured Naku Nayak on his head and neck. He has attacked 3 times to Naku Nayak with a dao. Later, Naku Nayak died on the spot. At that time, many people gathered there, but no one went there to save Naku Nayak, as Sri Rajan Nayak has a dao in his hand. He was otherwise an eyewitness.
Lord, this statement are not
161,
credible,
yes,
Lord.
yes. This is
Oh,
one.
that is okay, but
Because in AR 604, 2004, Supreme Court 2943, it has been held by the Supreme Court, my lord. The statement recorded under section 161 is not evidence, and as such, undue importance cannot be given to such a statement, my lord.
Now, this
So
statement,
I
of
am not
course,
going
even,
to that statement, my lord. That statement cannot be taken into consideration.
even by
And I
taking,
have already told your lordship, Lord, that the IO is very enthusiastic. He wants to make the case very tight, by all means. So he might have recorded the statement. Otherwise also, what said that was not mentioned according to his version, he wrote it. So he has not been during cross-examination also, or during examination in court also, IO has not been, that thing has not been clarified that such and such witnesses were so stated like that before you. That was not brought. During trial.
even I cannot take a recourse to section 33 of evidence, because there also one has to be cross-examined. Any person who is dead, his statement can be relevant, but only after his cross-examination and all. This
no.
33, Lordship will see. 33 of the evidence. It has to be like tested, his statements.
If that statement is-
No, this 33 is a statement in the judicial proceeding.
In a judicial or any officer, entitled to take
No,
evidence.
32 is a different situation than 33.
32 is different, 33.
33,
only-
you see, I'll tell you what happens is then, supposing there's a cross case going on.
Oh, yes.
And then one person stood as witness in that judicial proceeding and he was cross-examined. Therefore, those evidence, normally in the trial court, we say we tender that evidence. And on tendering such evidence, it becomes a part of the record of this cross case also.
But then not only judicial proceeding, there is one more statement added to it, or before any officer authorized by law to take it. It
Yes,
can be the police officer also.
no. He's not authorized to take evidence.
Evidence,
No,
evidence.
you come to section 1.
Evidence.
Come to section 1. It extends to hold except so and so to all judicial proceeding or before any court so and so, not to affidavit preliminary court, not to proceeding before an arbitrator, so and so. So this is very specific. Who can take evidence
Huh.
is there. Now come to interpretation clause 3 first, court.
Evidence is defined.
No.
Ah,
Court.
court, yes.
Yes, court includes all judges, magistrates, and all persons except arbiters legally authorized to take evidence. Clear? Don't have that copper.
Yes.
When in 33 it says authorized to take evidence, we have to read it within that provision,
Oh, yes.
and therefore court.
Except arbitrators legally authorized to take. So by saying legally authorized, it can be mean arbitrators. It can mean arbitrators,
No.
but not
Is excluded.
except arbitrators, comma.
All
legally-
persons except arbitrators.
Huh.
That is an exception is carved out.
Except arbitrators legally authorized to take
Yes.
evidence.
So
So
you see
only
what
judges and magistrates.
you see what happens is that let us say that we make you a commissioner.
Ah.
And we ask you to go there and make an inquiry, take evidence and report it to us.
Ah.
So therefore you are legally authorized to take evidence as a commissioner. That is why we say I'm commissioner within the meaning of CPC section 20 or order 26 rule 9.
Yes.
We authorize you to take evidence and therefore that is permissible.
So 33 will not come.
33 will not come.
I'm obliged, I didn't see this. So Chintamani's evidence we cannot take.
We cannot take. Third, Mr. P.C. Das, learned legal aid counsel, appearing for the appellant, as well as Ms. S. Jahan, learned APP for the state. This appeal from jail CRPC. CRPC. Has been received as provided for under section 383 CRPC. And as per and has been 383 read with 374 CRPC. Most of the appeal is directed against the judgment and sentence dated 17/12/2018, passed by the learned additional session judge, FTC, Biswanath Sariali, Sonitpur, in sessions case number 168 of 2014, under section 302 CRP 2 IPC, which arises out of GR case number 289 of 2013. corresponding to Bihali PS case number 73 of 2013, by which the sole appellant was convicted for committing offense under section 302 IPC and was sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 2,000, in default, to undergo further rigorous imprisonment for 1 month. Next paragraph. In brief, the case of the prosecution is that on 25/4/2013, the complainant, namely Srimati Sukurmoni, Sukurmoni, Nayak, had filed an ejar with the in charge of Borgang, Bargang outpost. It is Borgang or Behali? In the serial list and all, there is called Behali. No,
Bihali is the police station.
Behali is the police station. No, FIR is lost before Behali outpost on 25/4. Oh, it is Borgang.
It's at page 5, my lord. The paper book.
Oh, yes, it is Borgang. Borgang outpost. Under Behali police station. That on the previous day at about 5 p.m. The previous day, that on 24/4/2013. Don't make it previous day. 24/2000 at around 5 p.m. The appellant had killed her son, 26-year-old son, namely Nasu Nayak Nayak, by hacking him on his neck and head with a dao over the matter of a catapult, CATAPULT. And accordingly, prayer was made to take necessary action against the appellant and against the appellant. To stop. The ejar lost before the Borgang outpost was sent for registration to the officer in charge for Behali police station for registering a case. And accordingly, Behali PS case number 73 of 2013 under section 302 IPC was registered. Next paragraph. The matter was entrusted for investigation to Rajiv Gohai, RAJIB, Gohai, GOHAIM, IC Borgang outpost. Full stop. In course of investigation, the IO had prepared a scissor list, corrected the postmortem report, and also submitted a charge sheet in the case on 30/6/2013 on finding prima facie case made out against the appellant. Full stop. The learned subdivisional judicial magistrate within bracket M, Biswanath Sariali, on finding that the offense was exclusively triable by the Court of Sessions, committed the case for trial before the Court of Additional Sessions Judge, FTC Biswanath Sariali. Full stop. After the requisite and prescribed, in compliance with the prescribed formalities, charges were explained to the appellant on 29/8/2014, and on charges being read over and explained, the appellant pleaded not guilty and claimed to be tried. Next, during trial, the prosecution had examined 7 witnesses, namely at page 31, 1 to 3, 1 to 7, and had exhibited the 3 following documents. Same page, and also exhibited thou as material exhibit number 1, material exhibit 1. Full stop. The incriminating materials were brought to the notice of the appellant during his examination under section 1313 CRPC. Full stop. Not full stop, comma, to which the appellant pleaded denial, claiming the allegations to be false, but declined to give any defense evidence. Next para. The learned trial court formulated point of determination as follows. Subpara. Whether the accused on the day of the alleged occurrence committed murder of Nathu, Nathu, Nayak, Nayk, by intentionally causing his death. Full stop. On the basis of the evidence on record, the learned trial court took the aid of Section 106 of the Evidence Act, page 28. And based on discussion of the case of Shambhu Nath Mehra, Hambu Nath Mehra, Mehra versus State of Ajmer, AR 1956, SC 404, and Etigal ATTY GALLE versus Emperor, AR 1936, PC 167, and Senvit Ratne, SENEVIRATNE versus R within bracket 1936 bracket was 3 all ALL ER, 36. Well, that the burden did not lie on an accused person to show that he had not committed the crime for which he was tried. You write it this way, the language is right way. Page 29, para 22. Arrived at the conclusion that, inverted commas, it is evident that that cannot be the intention, and the Privy Council has twice refused to construe pencil mark.
We cannot simply burden people with you.
Right there. You just say, citing on so and so, the first case, Shambhu Nath Mehra versus so and so, refer to observations of the Supreme Court of India in paragraph 9 thereof. And it appears that the Iran trial court heavily relied on the evidence of PW7 as regards seizure of the dhow, material exhibit 1 from the place of occurrence, which was lying near the dead body, and had arrived at a conclusion that the appellant had intentionally caused fatal injuries on Nathu Nayak with the seized dhow, which resulted in his death. And accordingly, it was held that the prosecution had been able to establish charge against the appellant on the sole point of determination. And accordingly, the same was answered in the positive, holding the appellant guilty of offense committed under section 302 IPC. Full stop. On the question of sentence, the learned trial court considered the nature of offense and imposed minimum punishment of imprisonment for life for committing offense under section 1302 IPC. And accordingly, sentence as indicated above was passed. Next para. The learned legal aid counsel has submitted that there are three, that the witnesses can be classified into three categories. PW 1 and 4, who can be said to be eyewitnesses. PW 3 and 4 no, sorry, 2 and 3 are hearsay witnesses. 1 and 4 are eyewitnesses. 2 and 3 are 2, 3, and 5 are hearsay witnesses. And there are two official witnesses, being PW 6, who is the IO, and sorry, who's the medical officer who had conducted the postmortem examination. And prepared the report, and PW 7, who is the IO of the case. Next, it is submitted that the credibility of the evidence of PW 1 can be discarded because of the evidence of PW 2, who had clearly stated that there were several houses in between the place of occurrence and the house of the deceased, and the place of occurrence was not visible from the house of the complainant. Stop. It was submitted that PW 2 is the brother of the deceased. And therefore, he has submitted that the Dhaned trial court has rightly discarded the evidence of PW 1. And he has supported the said finding. Full stop. He has discarded the evidence of PW 1, 2, 3, and 5 on the ground that they are hearsay witnesses, and they cannot be reliant on their evidence, but rather not seen the who had not seen the occurrence. Full stop. Next, the legal aid counsel has submitted that the evidence of PW 4, Bhaben Mali, BHABEN, Mali MALI, can be discarded because of the fact that although he claims to be an eyewitness and saw and purportedly saw the appellant hitting the deceased on his back, but it is submitted that except for the injuries in the occipital region, of the deceased, as per the postmortem report of PW6, namely Basanta Kumar Bora, Dr. Basanta, BASNTA, Kumar Bora, BURAH. There were cut injuries over the occipital region of the scalp of size 5 cm into 1 cm into full thickness of the scalp, and the deceased had suffered multiple cut injuries over the front and right side of the neck involving the thyroid cartilage and larynx, LARYNX. Accordingly, it is submitted that if the injuries are to be believed, the nature of injuries are to be believed, it would make the attack from backside impossible, as those injuries, as those cut injuries can only be inflicted from the frontal side. So in this connection, the Learned Legal Aid Council has referred to the cross-examination of PW1, who had denied that, PW4, who had denied that it was not, that he denied that he did not state before the police that the appellant hit the deceased on his backside with a dao, and had also referred to the cross-examination of the IO, PW7, who had specifically stated that the witness, Bhaven Mali, within bracket PW4, did not tell him that the appellant had assaulted the deceased on his back. So hence, it is submitted that the ocular evidence of PW4 was at variance from the medical opinion with regard to death, with regard to injuries which had caused death of the deceased. So it was submitted that the next paragraph was submitted that the evidence of the doctor within bracket PW6 cannot lead to an inference that the deceased died because of assault made by the appellant. Next paragraph, referring to the evidence of the IO within bracket PW7, committee submitted that the IO cannot be believed, as he had tried to frame the appellant by collecting the dao, which is the appellant, which is suspected to be the offense of assault,
Weapon.
weapon of assault. Weapons of, from the place of occurrence. And in the same statement, he has also stated that he had seized the sharp dao from the place of occurrence. Now, where did you say that he seized it from from the,
The statement.
hmm?
Police statement says that it was lying on the ground
Page 36.
and in the future list from possession.
Oh, acha. Always seized from the place of occurrence, having found it lying from the dead, lying near the dead body at the place of occurrence, comma, but in the seizure list within bracket exhibit 2, comma, the seizure is said to have been made from the position of the appellant. Stop. Hence, comma, it was submitted that the IO had attempted to manufacture an evidence to implicate the appellant. Stop. It is also submitted that although as per the evidence of PW4, 7 or 8 persons were with him when he saw the occurrence. But but the IO did not examine any such independent witnesses. And therefore, the evidence of only interested witnesses were recorded to implicate the appellant. So moreover, it is submitted that the weapon of offense, i.e. the dao within bracket material exhibit 1, was not sent for forensic examination. Forensic examination and obligor serological examination and did not seize any blood-stained cloth or articles from the place of occurrence. And moreover, in the sketch map prepared, comma, the house of PW1 or the nursery of PW4 were not shown. And moreover, the sketch map itself was not exhibited before the learned trial court. Hence, it is submitted that the evidence of PW7 ought to have been disbelieved by the prosecution, by the learned trial court. Next paragraph. The learned additional PP has submitted that the evidence of PW4 cannot be discarded only on the ground that he had stated that he had seen the assault from the back. No, that he has seen the appellant assaulting the deceased from at the back. So in this regard, it is submitted that the fact that he had seen the assault could not be disproved. And it is submitted that it is also possible that even by striking from the behind, cut injuries of the description mentioned in the postmortem report could be inflicted. And moreover, it is submitted that the deceased had a cut injury in the occipital region of the head, which is at the hind side, HIND, hind side of the had so in the said connection, it is submitted that from the case diary which is available with the LCR, it can be seen that the PW4 had given a statement before the IO regarding assault on the assault by the appellant on the deceased. Hence, it is submitted that the evidence of PW4 being sterling in nature can be the sole evidence for convicting the appellant. So accordingly, she is submitted in support of the impugned judgment and sentence. Jan, that is the only point you are urging. Next para. The learned amicus curiae has submitted that has brought to the notice of the court that this court by order dated 25/3/2022 had granted bail to the appellant by order dated 25/3/2022 passed in IS criminal number 655 of 2019 arising out of the instant appeal. First off, however, he has submitted that as per his information, as the appellant could not furnish a bail bond, he is still serving his sentence. Okay, that much. It is a BC Das for the appellant and the arguments are concluded, judgment reserved. We have reserved the judgment. We have recorded your statement in your presence so that there's no mistake in appreciation. Yes, Mr. Chaudhary. Saw you after a long time. Yes, Ms. Burman.
Item 3.
Just a moment. Mrs. Burman, just from just wait, we'll take a break and then we'll resume.
এই ভিডিও অর্ডার এটা হল মোট আছে নি
Not
and 19, in section case number 100 of the 2017 and the 302 to the SCC. By this judgment, accused has been convicted for life and with a fine of 10,000 and in default, 3 months more.
Yes.
In this matter, my lord, the accused happens to be a garden laborer, my lord. Informant is the owner of the garden who has lost a FIR on page 4 is exhibit 1. This is the FIR, my lord.
Yes.
Humble submission is that around 4 p.m. on 23rd 10/2016, Shibu Korwa, a worker of my garden, situated at Toitha Gaon, in his wife, Sumanti Panita, by assaulting. At present, the dead body is in our neighbor house of the garden. I therefore pray to you take necessary action by investigating into the matters and oblige. Informant is garden owner, my lord. Based upon this FIR, is case number 153 of the 16 under 2000, under section 303 is registered in Namur police case in the police station. Informant is examined as KW1 member. His name is Gauri Dharia.
Yes.
And I am the complainant. I know the accused person. The deceased was accused person's wife. The accused worked in my garden and raised there, resided there. In the accused person's house, the accused person and his wife lived. The occurrence took place about 2 years back. The occurrence took place around 5 p.m. and at the time I was at my house. At the time, uh, Kalia Urang, an employee of my garden, informed me over phone that Sibu had assaulted his wife and kept her inside, and he was sitting in the front side of his house with a dog. Getting the information, I went to Sibu's house with Kalia and others and found Sibu outside his house and saw a dog in his hand. I asked Kalia and others to enter his house, and when they came out, they told me that Sibu's wife was lying on the bed and perhaps she had died. Then I informed at the police station. Police came and took Shibu and dead body. When I asked, I was told that accused had assaulted his wife. I lodged the Ajahar on that day itself. Exhibit 1 is Ajahar lodged by me. 1 is my signature diary. Police agent Ho, in front of me. Exhibit 4-2 is the Sager list and exhibit 2-1 is my signature diary. Has to be. That here is, my lord, Ho is a tool, it's a garden tool, my lord. It's not exactly the dowel, which has a long handle that is usually used for uh, uh, turning the soil for removing plants that are not wanted within that cultivation purpose, my lord. It is not in cross, it is stated that it is not a fact that I did not state during investigation that I have received the information from Kalia and the accused person was waiting with a doubt. It is not a fact that accused person did not tell me that he had assaulted his wife. It is not a fact that I did not state during investigation that Kalia and others had entered into the house of the accused person. I did not witness the incident. It is not a fact that the hope was not safe in front of me. Here is my lord, he is not the eyewitness. On being informed by his one of the employee, he went to the place of occurrence and had seen the accused person with the dead body, my lord. And he is holding his dog in his hand, my lord, which is seized by the police. Page 12, he is the PW12. His name is Sri Kalia Oram, and he is a garden laborer, garden worker. I am a worker in the garden of the informant. I know that accused and I knew the deceased who was the wife of the accused. The occurrence took place about a year ago at about 6 p.m. On the day of incident at about 5-6 p.m., my daughter Kokila, who was in the house of the accused, informed me that the accused had beaten his wife. Thereafter, I went to house of the accused and knocked his door, but he refused to open the same. Accordingly, I informed the informant about it. On receipt of the information from the informant, arrived at the house of the accused and asked me to call the accused. Thereafter, the accused came out of the house, and I entered into the house and saw the dead body of the wife of the accused. At that time, accused was drunk. The informant informed the police that after some time, police also arrived here and took away the dead body. In the house of the accused, couple lived together. On arrival, police said some articles in my presence. I put thumb impression in the seizure list. Material exhibit is a spade, which was seized by the police. Material exhibit 2 is empty bottle. Material exhibit 3, 4, 5 are the clothes seized by the police, which I have seen today. In cross, he said, I did not witness the occurrence with my own eyes. It is not a fact that during investigation, I did not state before investigating officer that my daughter was in the house of the accused and she informed me about the occurrence. It is not a fact that I did not state during investigation that accused was drunk. There are 3 houses adjacent to the house of the accused. I put my thumb impression in a blank sheet of paper. It is not a fact that the police made no seizure in my presence. Here is also my lord. He is not the eyewitness. On being informed by his daughter, he has went to the place of occurrence and see the accused with the dead body inside the house, my lord. And there was also material exhibits are also there, which she has seen. And one thing, my lord, in his statement, he has stated about the drunken situation of the accused, my lord, which the exhibit, PW1 has not stated anything about that, my lord. PW3 is the doctor, my lord, who has done the postmortem, my lord. Dr. Debasri Chakraborty. Here is, my lord, on 24/10/2016, I performed most postmortem examination on the dead body of Sumanti Karwa, 32 years female, in connection with reference number Namrud Police Station case number 153 of the 16 under section 302 IPC. Body was identified by Constable 946 Sujit Rohai. On external examination, I found female dead body of average build, warty complexion, eyes closed and mouth partially open, found wearing a green sari and found wrapped in a plastic. The rigor mortis was found to be fully developed all over the body and the body was full to touch both externally and internally. Thereafter, my lord, there are 5 injury marks in that has been written in the postmortem report. Accordingly, all these are depicted here, my lord, in his statement. And last part of page 15, my lord, last paragraph from the bottom, my lord. Regarding visceras, he kept officer concerned, my lord, medical officer concerned kept the viscera for forensic, my lord. That part is noted. Regarding viscera, the following viscera were kept and preserved, and experts in police was requested to take them to Forensic Science Laboratory, Kahalipara, for chemical analysis. jar 1, jar 2, and jar 3. These are the parts, my lord. In jar 1 contains stomach and its contents in preservative. Jar 2 contains portions of lungs, liver, brain, one half of the with kidney in preservative, and jar 3 contains sample of saturated solution of common salt used for preservative. Two vaginal swabs having taken and slides prepared and examined under microscope, but no uh, spermatozoa was detected. During autopsy, externally 5 injuries were found over the dead body, which were caused by blunt force impact. The injury over the membranes, that is subdural hemorrhage and subarachnoid, is sufficient to ordinary course of nature. After autopsy, I did not give final opinion. Here is my lord in the postmortem report. Examining doctor did not give his opinion regarding the cause of death, my lord. As both his parts, these in 3 jars, the viscera and other parts were sent for forensic laboratory for examination, chemical examination, my lord. Later on, that examination come and that is also exhibited, my lord, in the charge sheet. And there is no such harm regarding any intoxication or any poisoning such thing, my lord. It was come later on, my lord. During in cross, my lord, it is stated, during autopsy, I suspected that poisonous substance might have been present in the dead body, for which I referred the viscera for chemical examination. I did not receive any report from the forensic science laboratory. I did not give my concluding remark regarding the cause of death. When the dead body was brought before me, no weapon was shown to me by the police personnel who had brought the dead body. The injury over membranes was internal one. In my part, in my report, I have not specifically mentioned that the injury over the membranes might cause the death of physics. The injury over membranes might have been caused due to collision against a hard substance. Here, Dr. Milo, that she did not stated anything about the weapon that has been used, whether it is blunt or it is a sharp weapon regarding cause of injury, by which that cause of injury has been offered, my lord. Number 4, Sunil Parwa, page 17, my lord. He is a garden laborer. I know complainant. He is the owner of the tea estate where I work. The accused person and I took in the same tea estate. The deceased was accused person's wife. The occurrence took place around 4:30 p.m. about 1 year ago,
Just a moment.
my lord.
Resolution. Google dictionary আছে Google what is what Google dictionary আছে এটা আমার ইমান মোটা clearing the tissues. Solution is being put in a level. Dismemberment हो रही है कितनी कठिन तो चाहिए ऐसे लिखे ऐसे in cutting dismemberment तो clear हो गया yes
Injury part, I will pick up with it. That's not an issue. Next witness is PW4, my lord. He is a garden laborer. She worked with us, work along with the deceased person, my lord. Page 18, so reading, my lord. At that time, I was at home. Some of my neighbors told me that the accused and his wife engaged in quarreling. On receipt of the information, Kalia Orang and I went to accused person's house and informant the owner of the tea estate. On receiving the information, the owner of the tea estate also arrived at the accused person's house. Arriving there, we found the doors of the accused person's house shut and he was inside his house. The owner of the tea estate, Gauri Darial, told the accused person to open the door, and when he opened the door, Kalia and I entered inside and saw that accused person's wife was lying dead on the bed and her body was covered with a cloth. We saw bloodstains go inside the house. Then the owner informed the police. When police came and asked us to take the dead body out, we did so. Police seized hoe, bottle, cloth, and I put my thumb impression in the CJ list. I have been the I have seen the says cloth, hoe, and bottle, etc. in the court today. Material exhibit is the hoe with handle. Material exhibit 2 is the bottle and material exhibit 3, 4 and 5 are says cloths. Police interrogated me. In cross, my lord, he stated it is not.
That's how one, you know. Mhm. Yes,
Cross, he has reaffirmed the same thing, my lord. Page 18, the last paragraph. It is not a fact that during investigation, I did not state that Kalia and I went to accused person's house. That I informed the owner that I saw a bloodstained boat, that police came, that articles were said and seized, and that the dead body was covered with cloths. Last line, he stated that I did not witness how the accused person's wife died or who killed her. Next one is, my lord, page 20, PW5. He is also a daily laborer. He stated, my lord, in his evidence that I know the complainant and accused person. I knew the deceased around 10 a.m. One day, probably it has to be that day, my lord, day of occurrence. When I was going for my work, I saw that fetching water from a drain. The accused was pouring the same on his wife's head, and his wife was shouting not to do that. I asked him not to do so and left. When I was in the shop in the afternoon, I heard that the accused has killed his wife. On receipt of the information, I went to the accused person's house, and at that time, police also came there. I saw the accused person's wife lying dead on the bed of his house. Police took my signature on paper. Exhibit 2 is the seizure list, and Exhibit 2 is my signature thereon. Again, in his statement in regarding cross, my lord, it is not a fact that I did not state before police that I have stated today. I cannot say how the wife of the accused died. Police did not say anything in front of me. So here that contradiction regarding his signature in the paper, which is happened to be the seizure list, my lord. And he also stated he did not know how the wife was died, my lord. One aspect he also stated in regarding the quarrel. At the daytime, he saw the accused person. He made the wife of a quarrel and doing some untoward thing, which according to him ought not to do, my lord. PW6 is the IO, my lord, investigation officer. In his statement, it is stated on 23rd 10 2016, I was working as second officer at Namrup Police Station. On that day, officer in charge, Namrup Police Station, received one Ejahar which was lost by Sri Gauri Darial, alleging that Sibu had murdered his wife. On receipt of the FIR, a case was registered by Namrup Police Station, case number 153 of 16, and entrusted me to investigate into the case. Taking over the charge of investigation, I rushed to the place of occurrence and examined the informant and the witnesses. I found that the accused was detained by the local people. I also found the dead body of the wife of the accused in his house. I found one spade, one bottle in the room where the deceased was found lying. I arrested the accused, getting sufficient materials against him, and I took dead body to the police station where inquest was done, and thereafter it was sent for the postmortem.
Ms. Burman, just a moment. What is the legal effect of there being no final report in the postmortem report?
Lordship, because it was sent for the Viscera Lordship. And that has been received later on. FSLU.
It's received later on
Yes, yes.
and exhibited.
Yes.
Oh, acha, okay.
Whereupon it is found that no such,
No poison
no
was
poisoning like
detected,
situation.
Lordship.
Okay, poisoning is not there, but final opinion is there. Okay.
That is exhibited, my lord, also. in
Exhibit?
side sheet also.
6. Okay.
Side sheet also, my lord, it was my lordship.
No, it's okay. We were just.
I'm coming to.
Page 60.
No, it's okay. If it is there, it is okay. Otherwise, we were trying to address that issue.
Closing by the doctor concerned, my lord, that report was not come.
No, it's okay.
As a
Okay.
draft, so that is why.
So once it is there, it is okay.
Yes. Last para, page 22, my lord, the police officer has mounted exhibits, my lord, that is along with material exhibits and other exhibits, my lord. In Ross, he stated, I examined all the witnesses on the day of incident. I arrived at the place of occurrence at 9:15 AM. The PW1 Gauri Darial did not state during investigation that the accused was waiting with a doubt, and he also did not state that accused has confessed his guilt. The PW2 Kalia Orang did not state that the accused was drunk at the time of the incident. I did not examine Duran Gogoi during investigation. I did not record the statement of Okhila Orang. I prepared a sketch on the date of incident, but in the sketch, I had not written the name of the person who identified the place of occurrence. As per the sketch, there was only 2 houses near the place of occurrence. It is not a fact that the sketch prepared by me is a faulty one, as there were many houses near the place of occurrence. Next page, my lord, page 24 is 313 statement of the accused, my lord, where he has denied all the explanation that is given to him, but the last question, my lord, at page 26, last question, my lord. What do you want to say? In his defense, my lord, it was put before him. The allegation against me is a false. My wife died by consuming poison. He only stated that much in his defense, my lord. Rest part regarding assault and my lord, using of Dow bloodstains, material exhibit saying all these things he has denied, my lord. Next, my lord, kindly turn up to Exhibit 3, page 43 is the post-mortem report, my lord. Page 44, that at clause 2, my lord, position and character regarding injuries, my lord. All this 1, 2, 3, 4, and 5. All the 5 injuries are stated, my lord, which are in basically scalp area, occipital area, scalp area, my lord, and the marks of laceration marks of size, etc., are also there, my lord. And that forensic part is also next paragraph, my lord. The following viscera are kept preserved and the escorting police is requested to take them to DFS Kahilipara for chemical analysis. That jar 1, 2, and 3 that contains are mentioned, my lord. That's page 45. Thereafter, my lord, kindly turn to page 48, where is that opinion of the assistant surgeon, my lord. Opinion regarding the cause of the death is kept pending till the receipt of chemical analysis report from DFS Kahilipara, Guwahati. However, all the injuries described were antemortem and caused by blunt force impact. Approximate time since death 12 to 24 hours. Next, my lord, I would like to present page 50, that is Exhibit 4, Inquest Report, my lord. At clause 12, page 52. It is stated, opinion of witnesses and police about the cause of death and weapons of the instrument used thereof, if any. Cause death due to grievous hurt by blunt object. Page 52, number 12. Thereafter, my lord, turn to that chart sheet, which is exhibit number 6, my lord, page 57. And page 60, clause 7 is the relevant portion, my lord. The prosecution story of the case is that on 23rd 10/2016 at about 8:40 p.m., the complainant of the case lodged the FIR at this PS to the effect that on 23rd 10/2016 at 4 p.m., one Sri Sibu Karua assaulted his wife on 23rd 10/16 at about 4 p.m., namely Ms. Sumonti Honika. As a result, she succumbed to her injuries, hence the case. During investigation, a prima facie case under Section 302 IPC has been found well established against the alleged accused person, namely Sri Sibu Karwa, son of late Mongol Karwa, resident of Tiniali Hill State, PS Tinkhong, District Dibrugarh. So I beg to send up him to stand trial under aforesaid section of law. The accused person had been arrested and forwarded to judicial custody. The deceased was sent to PM examination after whole inquest by executive magistrate. As per the PM report, the cause of death is kept pending till the receipt of chemical analysis report from DFS Kahilipara. But however, all the injuries described were antemortem and caused by blunt force impact. Moreover, the FSL report from the DFS Kahilipara, Guwahati also collected were opined that no poison was found in the exhibit number TOX. These are the A to F are the exhibits, my lord, in FSL report. These witnesses mentioned in column number 6 will prove the case and them may kindly be summoned during the time of trial. Rough sketch map of the place of occurrence, usually inquest report, PM report, and FSL report enclosed herewith.
Okay, we'll continue some other day. Second half will not be resuming. The single bench of my esteemed brother. Yes. For this, I'm Government Legal Counsel for the Legal Aid Council for the. You're a legal aid or amicus? I'm a learned amicus query in the matter. Her submissions remain inconclusive. Message Baral and APP is present. List as a part of matter on 30/1/2023. It's here. In this item one, I think there's a jinx in this court with regard to this matter. You look at your annexure 3 or 4, that is the letter of acceptance. That is for lot number 2. Your agreement is on lot number 4.
Probably.
I don't know, you just take it up. Because when I started dictation, then this is the first thing where last time also it was a very small matter of registration. I don't know what is happening in this matter. Is there some kind of a jinx?
Sometimes it does happen.
Let's check it up.
Yes, I'll do that.
We've sent you these files. The agreement is on lot number 4 and the document is on lot number 2.
Error, Malak, sir.
Letter of acceptance.
Yes, page 60
Huh.
for lot number 2.
Lot number 2.
Yes.
But the cases are lot number 4.
Yes, page 61 is the
Hmm.
agreement, which is for lot number.
4, correct.
Compliance circle.
The second case is okay. First case, this.
See page 60. 60 for a moment. 60, if you see, is the subject therein refers to lot 2.
That is, 67 for this.
Okay.
67 and 63. The present is falls from 63 and 67. It is not for. We supposed to follow the case about lot 4.
Now look at the cost title. Look at the cost title also, page 2 or 3. Which is that lot?
Lot number 4. I have.
Lot 2 and lot 4. Because what has been done is the documents related to lot 2 and lot 4 both have been filed together. But they should have been more careful about the segregation in lot 2, which should be only lot.
You flag this lot, the first case is of lot number? Lot number 4. Just flag it. Because when I was dictating, there was a mismatch and therefore.
For 70, on such flat 3 pages, just to demonstrate Malak, the.
Let me have the document.
Yes, ma'am. So very much. would see sequentially, unless the first will be the lot 4 being mentioned at the cost title, unless, and the
Yes,
Malas would see the second flag would relate to Malas, the contract agreement being entered into between lot 4
yes,
and 67 Malas, the third flag is a letter of acceptance of lot. Subject Malas would see the subject over there, it's a letter of acceptance related to lot 4, bond gap. Yeah, Malas would see the subject, phase 2, lot 4, Bongian circle. Notification of Bongian circle.
lot number 4. Then what is in the third line? Notify that so-and-so implementation of so-and-so, lot number 2, Bangaigaon Circle. Text of the letter is lot number 2 again.
I feel Malas, now lot 2 has been referred wrongly, it should be lot 4 Malas, because Bongian is Malas lot 4. Lot 2 is another Malas circle, that stage put. Lot 2 is stage put Malas, lot 4. So there's a typographical error Malas in the letter,
Okay.
the running paragraph. Malas, that typographical could be because of the reason that at page 61 Malas would see. What my learned friend was also pointing out was otherwise a letter of acceptance related to other one.
61 is lot number 4.
Malas. 61 is lot number 4 Malas. 63 and 67 Malas would see. 63 is the document of contract, which is for lot 4. Malas 67 is the letter of acceptance related to lot 4. There's a typographical error of lot 4, lot 2 Malas. It should have been lot 4 because it relates.
Okay, in subject it is lot 4,
Yes,
but
Malas. In the running
down
paragraph,
below,
Malas, lot 2 has been wrongly
it's
written. It should
lot
be
2.
4. It should be lot 4 because it says about the description of the contract Malas. Mondial circle, because the other one is stated.
correct.
Malas.
Similarly, in the next annexure item number 2, my lord, arbitration 18, my lord may see as the subject matter, my lord, it's a lot 2.
Let's see the paper. Lords has pointed out very correctly, Manas, that one line, one word is being wrongly written is creating a lot of confusion Mal, about this.
Yes, this is lot number 2, Tejpur Circle.
And at page 60, my lord, our letter of acceptance. Lot 2, my lord.
No, this in this item 2, there was no issue. So only on this
My
first.
lords is correct, Malas, that is a typographical error. Because Malas, you
Okay.
see, lot 2 is Tejpur and lot 4 is Bondan.
Okay, correct.
Why?
Okay. Okay. Both sides of both sides are represented, and Mr. P. Bhutan, and counsel for the petitioner, has submitted that in that annexure 4 to arbitration petition 17 of 2023 contains the description of lot number 2 in the subject, but in paragraph 1,
Well, subject,
Yes,
subject is lot 4.
lot 4, comma Bangaigaon Circle. But in the paragraph in the first paragraph, there is a erroneous description of the lot by mentioning lot number 2, comma Bangaigaon Circle, which should have been which is a typographical error and should be read as lot 4, lot dash 4, Bangaigaon Circle. Mr. B. Chaudhary, learned counsel for the respondent number 1, and Mr. B. Das, learned counsel for respondent number 2, has no objection as to reading of para 1 of annexure 4 as lot number 4, Bangaigaon Circle. First, on the matter being clarified, comma, the matter stands reserved for delivery of orders.
And my lords, they are
Yes.
worthy of wishing a happy new year.
Thank you. But please go through this record once again. Please don't, what you call, just check it out. Please check it out, both the files, and then I'll take it back.
So verified. So verified.
CV থাকিব।
Plus the bench would be rising or? Deeply obliged one.